Your Honour, my name is Daniel Wallace, and I represent the plaintiff, Mr. Richard Waite. If it pleases the court, I would like to make a brief opening statement. My client, Mr. Waite, is a television broadcaster and family man who is married and has 2 young children. Mr. Waite brings this action in assault and battery against the defendant. This action involves a fight between Mr. Waite and the defendant after a basketball game that was played at the University Sport Complex in Robina. On the evening of the 13th of March 2012, Mr. Waite and the defendant played on opposing teams in a senior men's basketball game. After the game, Mr. Waite approached the defendant in the car park to discuss his rough and competitive nature. Mr. Waite and the defendant got into a physical altercation, and the ensuing consequences were particularly damaging to my client. The first issue in this case is about excessive force. We are not disputing that a fight took place, and not trying to assert that my client was not a willing participant. However, the evidence will show that the defendant took it one step too far. The second issue is about informed consent. The defendant is trained in karate and used that training against my client. My client had no knowledge of the defendant's karate training. The evidence will show that only 2 blows were struck, both by the defendant and both kicks. The first kick struck Mr. Waite in the stomach. The second kick fractured Mr. Waite's jaw, requiring it to be wide for 2 months. It is the second kick that gives rise to our claim of excessive force. We will be calling 2 witnesses, Mr. Waite and Mr. Edward Gore. Mr. Waite will testify that during the basketball game, the defendants elbowed him above the eye. As a result of the injury, Mr. Waite left the game. As he was leaving the sports complex to go to work, he noticed the defendant. My client decided to talk to him. Mr. Waite will then describe the events leading up to the 2 kicks and the breaking of his jaw. Your Honour, we will also be calling Mr. Edward Gore. Mr. Gore was at the game and is an eyewitness to the fight. He will testify that the second kick was excessive. Mr. Waite and Mr. Gore are the only 2 witnesses that we will call. Your Honour, my learned friend and I have come to an agreement with respect to damages, and no witnesses need to be called on that issue. I tender now the agreement as to the quantum of damages, which is the sum of $20,000, and I ask that it be marked as an exhibit. As the agreement shows, the defendant is agreeing only to the quantum of damages. Liability remains at issue. Your Honour, the plaintiff also abandons any claim for punitive damages. We assert that the defendant is liable for assault and battery, and through the use of excessive force, fractured Mr. Waite's jaw. This injury caused my client severe pain, suffering, and discomfort. Your Honour, that concludes my opening address, and with the leave of the court, I'm now ready to call the first witness for the plaintiff.